Okay, we're calling case number B2502219. This is State of Ohio versus Rodney L. Hinton. We're here today because Mr. Hinton has been indicted by the grand jury on the charges, two counts of aggravated murder with death penalty specifications, one count of murder, a specialty felony, and two counts of felonious assault. Mr. Hinton, if you want to be represented by an attorney but cannot afford one, I will appoint two attorneys who are certified by the Ohio Supreme Court to handle death penalty cases. If you hire your own attorney, he or she does not need to be death penalty certified. You can hire one, two, or as many lawyers as you want or can afford. If you are indigent and need an attorney appointed, I will select two attorneys that are certified by the Ohio Supreme Court. It is my understanding, sir, that you wish to hire your own attorney and in fact that you have retained Mr. Bennett to represent you. Is that correct?
Yes.
Mr. Bennett, you are representing him, isn't that correct? Okay, thank you so much. I do need to tell you, Mr. Hinton, I do believe that you have qualified for public defender appointment. Is that correct, Mr. Kennedy?
Yes, yes, Your Honor.
And in fact, was an affidavit prepared regarding his indigency?
Yes,
Okay, and was that affidavit filed with the clerk's office or with the courts?
it stays with the original case file and all the reports from that, but yes, it is, an affidavit stays with the actual qualification form case file and that occupies that original.
Okay, and thank you so much for that. That does not get filed with the clerk's office. Okay, just wanted to check and be sure. Okay, thank you so much, sir. I really appreciate that, being here. Okay, all right, so you have Mr. Bennett as your attorney. That's fine. We're good to go. I just wanted to make sure that was clear. And so what we will do is we will begin with the reading of the indictment. So, Ms. Sarah, if you would like to begin. First I will ask, has the defendant been served with a copy of the indictment? Okay, wonderful. And is counsel prepared to waive any defects in the service of the indictment? All right, thank you so much. I appreciate that. Go ahead, Ms. Sarah.
Aggravated murder with specification, one count murder, special felony, two counts felonious assault. Very stated that he was convicted of the indictment, hiding plea.
Okay. All right. So, Mr. Hinton, I need to go over some rights with you. Okay. So, the first and the second count of the indictment are aggravated murder, and it is what is called a special felony, and it carries with it the possibility of the death penalty, which may be imposed, making this what we call a capital murder case. Although a capital murder case is procedurally much more complicated, most of the rights you have in a death penalty case are the same as any other type of criminal matter. The aggravated murder charge is also accompanied by one specification, which we will talk about in just a minute, okay? You are presumed to be innocent, which means the state of Ohio has to prove that you are guilty if they can. They do this by calling witnesses to the stand and presenting evidence. All the witnesses have to testify in your presence, and your attorney will have the right to cross-examine each of these witnesses to test their truthfulness, and this is the right of confrontation. You have the right to call witnesses also, and if there are any witnesses who will not come to court voluntarily, I will order them by court to court by way of subpoena, and this is the right of compulsory process. You have the right to have this case heard by a jury of 12 people. They would hear and decide the evidence. All 12 must be convinced beyond a reasonable doubt of your guilt in this case in order for you to be convicted. If the jury finds you guilty of the crime and the specification, they can recommend the imposition of a death penalty. They can also recommend one of the life sentences options, which I will talk about in just a minute. In the alternative, you have the right to waive a jury and have the case tried to a 3-judge panel. In this event, myself and 2 other judges would hear the case, decide the evidence, and if necessary, determine the sentence. The trial will be bifurcated, that is, divided into 2 parts. One is the trial phase with either the jury or the 3-judge panel, and the second is the sentencing phase, which would happen if you have a jury or a 3-judge panel. Either way, there's still 2 phases to the trial. Okay? You understand? Okay. At the trial phase, the jury or the 3-judge panel will determine whether the state has proved beyond a reasonable doubt the crime of aggravated murder and whether the aggravated circumstances in the specification have been proven, also beyond a reasonable doubt. If you are found guilty of the principal offense, but not guilty of the specification, I will sentence you to one of the following sentences: life imprisonment without possibility of parole, life imprisonment without parole for 30 years, life imprisonment without parole for 25 years, or life imprisonment without parole for 20 years. If you are found guilty of the principal offense and the specification, we will move to a second phase of the trial known as the sentencing phase. The sentencing phase is presided over by the same jury or the same 3-judge panel that heard the trial. At this phase, the state has the burden of proving that aggravating circumstances are sufficient to outweigh the factors in mitigation. The aggravating circumstance in this case is that the offense was committed and that the victim, Larry Henderson, was a law enforcement officer and you had reasonable cause to know or knew he was a law enforcement officer, and either at the time he engaged in his duties or it was your specific purpose to kill a law enforcement officer. The prosecution has a burden of going forward with evidence that proves the aggravated circumstance. You have the burden of going forward with evidence of any factors in mitigation of the death penalty. Mitigating factors are those that lessen your moral culpability or diminish the appropriateness of the death penalty as a sentence. They can include your age, lack of prior criminal record, mental illness, etc. Just about anything can be a mitigating factor. The crime itself is not an aggravated circumstance, but it can be a mitigating factor depending upon the nature and the circumstance of the offense. You have the right to present evidence in the sentencing phase and have the right to compulsory process at this phase also. You have the right to remain silent at both the trial phase and the sentencing phase. This means no one can call you as a witness for the state. Whether or not you testify is up to you and your attorney. If you exercise your right to remain silent at the trial phase, the prosecutor is not allowed to comment on your silence, and I will instruct the jury not to hold your silence against you. At the sentencing phase, you can remain silent. You can testify under oath or make an unsworn statement. If you make an unsworn statement, you will not be subject to cross-examination. If the jury finds beyond a reasonable doubt the aggravating circumstances outweigh the mitigating factors, they will recommend a sentence of death. It is then incumbent upon me to make my own determination based upon a similar weighing process whether death is the appropriate sentence. If I agree with the jury's recommendation, I will impose the death penalty. If I do not agree with the jury's recommendation, I will impose a sentence of life imprisonment without the possibility of parole, or life imprisonment without parole for 30, 25, or 20 years. If the jury does not find beyond a reasonable doubt the aggravating circumstance outweighs the factors in mitigation, then one of the life sentences will be imposed. I will not be permitted to impose the death penalty without the unanimous recommendation from the jury. The verdict in the sentencing phase does not necessarily have to be unanimous. A single juror may prevent a death penalty recommendation by finding that the aggravating circumstance in the case does not outweigh the mitigating factors. However, all the jurors must agree before they can recommend a death penalty. If the jury is deadlocked and cannot reach a verdict at the sentencing phase, one of the life sentences will be imposed. If the case is being tried to a three-judge panel, a single judge can prevent the death penalty just like a juror can. If all three of the judges agree the mitigating circumstances outweigh the mitigating factors, the death penalty will be imposed. If the judges do not all agree on the death penalty, one of the life sentences will be imposed. A verdict resulting in the death penalty is automatically appealed to the Ohio Supreme Court. They will engage in the same weighing process as the jury and the judges to determine if the death penalty is appropriate. The indictment that you are facing also has additional charges besides the two aggravated murder charges. There is a count 3, which is a murder, which is a special felony, and that is a charge that carries 15 to life as a maximum penalty. There are also 2 felonious assault charges. Those are felonies of the first degree, and each one of those carries a possibility of 3 to 11 years at the Ohio Department of Corrections. Mr. Defendant, are you a citizen of the United States?
Yes.
And are you under the influence of alcohol or any drugs?
No.
Are you taking any medications right now?
Yes.
No?
Yes.
What medications are you taking, sir?
Laxapro.
I'm sorry?
Laxapro.
I can't hear you.
Laxapro.
Maxiprone? Laxapro. And what is that for, sir? I'm just asking to make sure that he knows what he's doing today so that he's of clear mind. I ask all, because he's entering his plea, that he's not intoxicated, he's not loopy, he's not under the influence of any drugs. I'm not trying to pry into anything, sir, but just to make sure he knows what he's doing here today. So you don't think he's high on drugs, that he's competent to stand here today? That's all I'm asking, Mr. Bennett.
I don't think, I think you understand the nature of the procedure.
Okay. All right. Then the plea is not guilty and will be entered as such. And anything else from the state? All right, thank you so much. Anything else from you, Mr. Bennett? I know that it's been a no bond hearing has been set and heard by Judge Yates, and the bond is currently no bond. Okay, anything further from anyone? Okay, I have a couple other further things that I want to say. All right, the defendant will be held and continue to be held without bond. Okay, I have a few more rights that I need to go over with you, Mr. Hinton. You have the right to have your case heard within a speedy amount of time. Generally, a person charged with a crime has the right to have their case heard within 270 days of that arrest. This incident supposedly occurred on May 2nd of 2025, and as soon as your statutory trial date should be somewhere around the beginning of February of 2026. There is a separate statute that says you have the right to have your untried indictment against you to be tried within 180 days of making a demand that your case be brought to trial. You would have to make that demand directly to the court and send a copy to the prosecutor. If you have done that, then the untried indictment date would be on or about beginning of November of 2025. You also have a right to a speedy trial under the United States Constitution, but there is no math in the analysis of this right. Rather, there are a number of factors that the court must consider. I'm going to set this case for a scheduling conference in the next week. At that time, we're going to pick a trial date, and between now and then, the attorneys are going to talk. Your attorney is going to talk to you about whether or not you want to waive your right to speedy trial or not. If you are not going to waive a speedy trial, then we need to figure out when the speedy trial date is and set that case appropriately. If you have any questions about what your speedy trial date is, you need to talk to your attorney and have them advise me on this issue. In addition to the scheduling conference next week, I anticipate there are going to be a number of pretrial hearings and conferences between now and the trial. Because this is a capital murder case, you are entitled to have an extraordinary level of due process. This necessitates that I check on things with you from time to time where ordinarily we wouldn't have talked between now and the trial. I also might ask you how you're being treated in the jail, how the food is, how things are, and how you're getting along yourself and with your defense team and things like that. We are not going to discuss the merits of the case, your trial strategy, or anything of that nature. But if there is something going on with you that affects these proceedings, I'm going to want to know about that and what it is, okay? Okay?
Okay.
Okay. I don't want to hear about every little disagreement you have with your attorney, if there are any. I'm used to do this kind of work, and I know that from experience, sometimes there are disagreements and they're going to happen, so that's really pretty normal. But if there is a breakdown in communication with you and your attorney, or if no one's visiting in you in the jail, or where you're locked up, or following any witnesses or discovery, I'm going to want to know about that, okay?
Okay.
Okay. I'm going to put down a preliminary case management order that will probably be next week after the pretrial. And so that's going to list the caption of the case, how things are going to proceed, when motions will be filed, how they should be captioned, who's going to use letters, numbers, a whole list of information about how I want this trial to proceed from both attorneys so there's no misunderstanding. So we're all on the same page and so that everything goes forward smoothly. At this next conference that we're going to have, the scheduling conference, I would like to discuss a tentative date for the state to provide initial discovery and a bill of particulars, procedure for the retention of experts by the defense, and to set that trial date. I would like to also talk about any competency issues or any sanity issues that might be raised, if any. I would also be in a position to pick a lot of the dates and the deadlines for everything that's going to happen in this case. I would also like the defendant to remain retained in the Claremont County Jail. Okay, so I'm going to put on an order setting the bond, keeping it remaining at no bond. I'm going to set the next scheduling date. I would like to meet next week. Are you all available next Thursday? And that would be what day? I'm sorry? May 22nd. Could everybody meet? Do we have could we meet at like, do you want to meet at 9 or maybe 11? What would be better for council? Okay, thank you. 11 o'clock. So May 22nd at 11 o'clock. And then I'm going to put on the order that the defendant remained housed at the Claremont County Jail. Is there anything further from the state? Is there anything further from the defense?
No.
Okay. All right. Thank you all very much. We'll see you all next Thursday. You're waiving time right now. Is that correct, Mr. Bennett? Till next Thursday? You're not waiving time?
No.
Okay. I do want a continuance entry signed by you and the state for this 1 week before you leave today. All right. Thank you.